Recent months, the CTA and the CFA and other unions boldly announced that they were jacking up the mandatory dues of California's public servants by tens of millions of dollars. The money has been earmarked and is being spent hand over fist to defeat a series of ballot propositions on November's ballot that happened to be opposed by union officials. Rank-and-file teachers, professors, and other government workers were not consulted, and they certainly were not allowed an opportunity to object to and prevent this extraordinary expenditure of their money for politics. The National Right to Work Legal Defense Foundation has received countless calls and emails from educators who believe the union's actions are an egregious violation of their First Amendment rights. They object to the forced extraction of dues for electioneering activity, much like you see behind us, and they ask for our help. Our attorneys examined the facts and found that the actions of these union officials fly in the face of the U.S. Constitution and the U.S. Supreme Court's precedent. Accordingly, the Foundation agreed to provide free legal assistance, just as we have in over 250 cases around the country involving a form of compulsory unionism abuse. By their actions, the CTA and CFA officials seem to have little respect for California's educators and view them as nothing more than an ATM to fund their political activities. And the union brass are breaking the bank to push their radical political agenda this fall. Most educators just want to teach their children. It is this passion that has led them to the profession of teaching. The fact is that many professionals want nothing to do with a union or this kind of politics, or its militant political agenda. In just the last 3 weeks, CTA officials wrote checks totaling more than $23 million to defeat several ballot propositions on November 8th's ballot. That's on top of at least $22 million already spent this summer. To the teachers standing here with me today, it really doesn't matter what the ballot measures are about, nor does it matter to the National Right to Work Foundation. The U.S. Supreme Court has established that employees should have an opportunity to object and to prevent their mandatory dues from being spent for politics of any kind, as well as any other union activity outside of collective bargaining. And union officials must give due process to these teachers before seizing their money for this kind of politics or any politics. They have not done so. It is an admitted fact that CTA raised these extraordinary sums through a $50 million bank loan secured by a dues increase of $60 per teacher per year over the next 3 years. The first dues deduction will occur in California at the end of this month. And more than 300,000 teachers will be forced to pay a mandatory special assessment. The first deduction of the California Faculty Association has already occurred. That's why a group of educators who are represented here at this press conference have stepped forward today to file a class action lawsuit in U.S. District Court to vindicate their rights and the rights of their colleagues. The teachers and professors filed this suit on behalf of all members and non-members of the California Teacher Association Union and all non-members of the California Faculty Association. Their attorneys, led by National Right to Work Foundation staff attorney Milton Patel, will be asking the U.S. District Court to enjoin CTA and CFA union officials from collection or further use of these forced dues until every single educator in the state is given a proper notice of what their rights are and an opportunity to object and to prevent this money from being spent for these political activities or anything else unrelated to collective bargaining. We will be asking the court to act sooner rather than later, forcing teachers even to give a loan to the union so that it can fund its electioneering would similarly violate their constitutional rights. The results of an election cannot be outdone. The time has come for union officials in California to respect the constitutional rights of the employees they claim to represent. Shame on them for gabbling them down. and taking their money to spend on this kind of partisan political activity. Respect for those who dissent may be a new concept for CTA and CFA officials, but it's the law, and the U.S. Constitution is on the side of the teachers represented in this lawsuit. I want to now introduce Judy Liegmann, a fifth-grade teacher from Sunnyvale, who is the lead plaintiff in this lawsuit. After her, we'll hear from special education teacher Jerry Smith from Riverside and State Senator Tom McClintock, who has come to offer his words of support and encouragement to these teachers. And at that time, we'd be happy to take any questions. Judy, come up and talk.
I see a placard here from our union that says, "Don't silence our voices." It would be wonderful if they would practice what they preach. My name is Judy Liegmann. I'm a fifth-grade teacher for the Sunnyvale School District. And I believe that the vast majority of my fellow teachers in California are still totally unaware that our union this month will begin deducting a hefty additional dues assessment from our paychecks. The reason is that the CT union officials notified none of us ahead of time that it was planning this money grab. Funds to be spent purely for political purposes. The union has given us teachers no time to react one way or the other. And that brings a question to my mind: what kind of treatment is that from an organization that purports to care about us and to represent us? Now, I'm a California teacher, and I do not feel represented by the CPA, the California Teachers Association, at all. I learned about the union's plans more or less by chance, shortly after their decision in June to charge us even more dues. I wrote a letter to the CTA requesting some information on how they plan to handle this dues assessment. I received no response. Subsequent phone calls and emails got me conflicting answers. First, I was told that I would certainly receive a rebate of the $60 fee hike, along with my regular rebate in October of this year. Shortly thereafter, the CTA informed me that the $60 would not be rebated to me. They were going to use my additional $60 for the November election, whether I liked it or not. I think this is the condition that all teachers in California are in right now. They have no clue that this is happening to them. I personally resent having a monolithic, powerful, coercive organization like the CTA announce to me what I think and then have the gall to tell me, and by the way, we're seizing your money to support what you're supposed to think. I personally would rather decide for myself, issue by issue, candidate by candidate, where I want to put my money to work. I'm sure that a huge percentage of California teachers share my wish to exercise their right to political autonomy. If there is anything the Constitution guarantees us, it is our right not to have our political opinions dictated to us, and our right not to have our property taken away by a private organization backing the state. The CTA should have given us teachers a chance to exercise our rights. CTA officials do not have a moral right to take that money from us, and we plead that the court take action quickly to protect our rights, our constitutional rights. To deny us that consideration would only compound the injustice. Thank you.
I'd next like to introduce Jerry Smith. She's a special education teacher from Riverside, California. Jerry.